State of Arkansas versus Damian Eccles, Charles Jason Baldwin, Craighead CR 93-450 450A. And we're also here on Clay Western CR 93-147, Jesse Lloyd Miskelly Jr. Counsel or the court notes that that all three defendants are present, and we're also present at a preliminary closed session hearing that was just conducted with no affirmative action being taken. It was simply in order to make sure that everybody was completely informed and on board as to what has been proposed to the court by the parties in this case. Counsel have been previously identified, and we have on behalf of Mr. Eccles, Mr. Dennis Reardon, Mr. Donald Horgan, Mr. Stephen Braga, Ms. Laura H. Nyrider, and Mr. Patrick Binka. We have counsel on behalf of Mr. Baldwin, Mr. Blake Hendricks, and Ms. Erin Casanelli. And we have counsel on behalf of Mr. Miskelly, Mr. Jeff Rosenzweig. The state is represented in this case by Mr. Scott Ellington, prosecutor for the 2nd Judicial District, and Deputy Prosecutors Melanie Allsworth, Michael Walden, and Alan Copeland. As indicated, subject to the court's approval, certain dispositive agreements has been reached by and between the state and the defendants in this case to bring a resolution to the issues in this case. I have been presented for review a conditional order for a new trial in this case, which, if approved by the court, would, in order to reinvest this court into jurisdiction of this matter, in order that this court might be in full power to do whatever is necessary to be done to implement the plea agreement and to enter final judgments and commitments in this case, would have to be approved, subject to additional steps to be taken upon which that is a condition. The conditional order for a new trial is one that's presented.
Necessary to grant the new trials, but recognizing that this granting of a new trial is on the condition that, or is on condition that certain other conditions are met after that, and those would be the entry of the pleas that are contemplated by the parties. I believe it contemplates entries by Mr. Eccles and Mr. Baldwin to 3 guilty pleas pursuant to Alford versus North Carolina, and everyone, I think, is aware that that's the method by which someone can enter a plea of guilty and still maintain innocence. Mr. Baldwin, Mr. Eccles would enter the pleas to 3 counts of murder. Mr. Miskelly, in accordance with more in line with his jury verdict in Clay County, would enter a plea to 1 first-degree murder count and 2 second-degree murder counts. On the first-degree murder count, he would give the same sentences as the others. Each of them involves a sentence to essentially, the court has the numbers in front of them. They are time-served sentences that would be followed by an additional period of suspended imposition of sentence that would last for 10 years from this date. That has certain conditions, obviously the most significant of which to be of law-abiding character and not violate the laws of the state of Arkansas or any other state. The state's position is that we're agreeable to a new trial being granted for that sole purpose.
The state acknowledges for the basis proposed to the court as a conditional new trial that there is basis for the court to grant a new trial in this case.
We acknowledge that the court, based on the record before it, could make that finding. And based on that, we are entering into this agreement, but again, for the sole purpose of allowing the pleas to take place, with the understanding that if the pleas don't take place, the court would rescind its order of a new trial. That would be revoked, and we would be back on the track that we've been for the last several years heading towards.
We'd proceed to gather evidence and have an evidentiary hearing on December 5th as scheduled towards the end of the court making a ruling as to whether or not it recommends a new trial in the case.
Is that sufficient?
I think so. I want to hear from the defense. Someone on behalf of Mr. Braga?
Yes, Your Honor. On behalf of Mr. Eccles, Mr. Waldman has accurately summarized the understanding between the parties. Mr. Eccles has been advised about it. We're agreeable to the conditional order for a new trial to implement the other two steps of the recommendation, the Alford plea and the sentence, which I understand we'll discuss a little more in detail later.
All right. Mr. Hendricks?
And Your Honor, I echo the words of Mr. Braga and Mr. Walden. This is a fair summary of the agreement that's been reached between the parties and the ultimate resolution of the case.
And Mr. Miskelly is in concurrence with everybody else.
Okay. And Mr. Eccles, you've heard what your counsel has said. You're in agreement with that.
Yes, sir.
And Mr. Baldwin?
Yes,
And Mr. Miskelly?
Yes, Your Honor.
Thank you. The court, having received evidence since we had our initial scheduling in this case, and hearing the proposal of the parties, believes that there is a basis in this case for its ordering a new trial conditional on the fulfillment of certain other requirements of this proposed Alford plea, and the court will enter a conditional order for a new trial at this time on behalf of both Mr. Eccles, Mr. Baldwin, and Mr. Miskelly. It's my understanding now, as relates to the, and an order will be entered to that effect. Now that we're at the state where the court has entered an order of new trial in the case, before we proceed on with the plea in the case, counsel, does the state wish to make, does the state have a recommendation or wish to modify the charges in this case before we proceed to sentencing and guilty plea?
Your Honor, yes. You have the paperwork there in your hands. The state will so move to amend the charges from previously filed to those reflecting first-degree murders, 3 counts for Mr. Eccles, first-degree murder, 3 counts for Mr. Baldwin, 1 first-degree murder, and 2 second-degree murders for Mr. Miskelly, commensurate with the negotiated plea that you have with you.
All right. All right. Court will so note, and charges will be modified accordingly. At this point in time, I want to proceed with the Alford plea. If you would, please, Mr. Eccles, Mr. Baldwin, Mr. Miskelly, if you would stand, please, and face the court and speak up loudly enough that you can be heard. You are Damian Eccles.
That's correct.
Mr. Eccles, how old are you?
I'm 36 years old.
How much education and schooling do you have?
9th grade, high school, completed a GED after that.
All right. Are you under the influence of any drugs, alcohol, medication, or substance?
None at all.
Okay. And Mr. Baldwin, how old are you?
I'm 34, Your Honor.
How much education and schooling do you have?
Completed 10th grade, earned my diploma through GED, and I have 30+ hours of college.
Are you under the influence of any drugs, alcohol, medication, or substance?
No, Your Honor.
Mr. Miskelly, how old are you, sir?
36.
How much education and schooling do you have?
9th grade, sir.
9th grade?
Yes, sir.
Do you read and write and understand English?
Yes, sir.
Have you been over all the paperwork with your counsel and had your questions answered and had things read to you that you could not read for yourself and fully understand what's going on here?
Yes, sir, I do.
All right. Are you under the influence of any drugs, alcohol, medication, or substance?
No, sir.
Okay. For the 3 of you here on charges, Mr. Eccles, Mr. Baldwin, you're here on charges of 3 counts of first-degree murder as opposed to capital murder. And Mr. Miskelly, you're here on charge of first-degree murder and 2 counts of second-degree murder. You understand that?
Yes, sir.
Do each of you understand that that you do not have to plead guilty in any form or fashion to any of these charges but have a right to go further, to go fully, to have the court proceed to rule as to whether or not you're entitled to a new trial. And if you be determined to be entitled to a new trial, to fully challenge the proceedings through trial, a new trial, through verdict, and if adverse to you, on appeal. Do you understand that, Mr. Eccles?
Yes, sir.
Do you understand that, Mr. Baldwin?
Yes, Your Honor.
And you understand that, Mr. Miskelly?
Yes, Your Honor.
And you understand that during those proceedings you would all have, as you have in the past, you'll all have you'd have a right to be fully and completely represented by counsel at all stages of the proceeding. Whether it be for determination of motions, whether it be determination of trial, whether it be subpoenaing witnesses, whether it be cross-examining state's witnesses as to whether or not to testify, and as to all your rights and obligations in the proceeding. Do you understand that, Mr. Eccles?
Yes, Your Honor.
You understand that, Mr. Baldwin?
Yes, Your Honor.
And Mr. Miskelly?
Yes, Your Honor.
Do you further understand that if you proceed forward with this plea, this Alford guilty plea, and it is accepted by the court, each of you will have waived and given up your right for the court to go to jury trial in this case, and you will have waived any right to appeal from any sentence that's imposed here today. Do you understand that, Mr. Eccles,
I do understand.
Mr. Baldwin, and Mr. Miskelly?
I do understand, Your Honor.
Knowing all this at this point in time, does counsel agree so far that the proceedings in this case are in the best interest of the defendants, Mr. Braga
Yes, we do, Your Honor.
and Mr. Hendricks
I do, Your Honor.
and Mr. Rosenzweig?
I do also, Your Honor.
At this point in time, I would like to ask the state to read a statement of agreed information that is going to be offered. It would be offered as evidence in this case if this matter went to trial, which, in addition to a more amplified statement made in chambers, would provide the basis for the plea. Ms. Allsworth?
Yes, Your Honor. The state would offer evidence in its case in chief that would substantially prove the guilt of all three defendants as follows. That on the evening of May 5th, 1993, 3 children were reported missing: Stephen Branch, Chris Byers, and Michael Moore. The next day, their bodies were found in an area known as Robin Hood Hills. The state would provide evidence as to a cause of death for each of these children, with the manner of death for each child being that of a homicide. That in the course of the investigation by the West Memphis Police Department, that the defendant, Jesse Miskelly, was interviewed and confessed his participation. That the state would also provide testimony that defendant Baldwin made incriminating statements while he was in juvenile detention, and that defendant Eccles also made incriminating statements to a group of individuals. Additional direct and circumstantial evidence would be offered by the state to prove the guilt of the defendants and would corroborate the statements made by each.
All right. Having heard those statements, Mr. Eccles, how do you wish to plead in this case?
Your Honor, I am innocent of these charges, but I'm entering an Alford guilty plea today based on the advice of my counsel and my understanding that it's in my best interest to do so, given the entire record of the case.
Have you been threatened or coerced or intimidated in any way to give rise to this plea?
No, sir, I have not.
And you are entering this plea because you believe that it is in your best interest to do so, and want to go this route as opposed to taking the risk of higher penalties and more penalties at trial.
That's correct.
Mr. Baldwin, having heard the statement made by the state as to a portion of the proof that's expected in this case, how do you choose to plead in this case?
Your Honor, first of all, I'm innocent of murdering Christopher Byers, Michael Moore, and Stephen Branch. However, after serving 18 years in the penitentiary for such, I agree that it is in the state's best interest as well as my own that based upon North Carolina versus Alford, that I plead guilty to first-degree murder in both crimes.
All right. And the same as relates to you, Mr. Miss Kelly, how do you wish to plead in response to the provable charges in this case?
I am pleading guilty under North Carolina versus Alford, the Arkansas rules. Although I am innocent, this plea is in my best interest.
All right, thank you. Do each of you, Mr. Eccles, are you fully and completely satisfied with the service, advice, counsel of all your attorneys that have been representing you in this case in connection with these post-conviction proceedings?
Very much so. Yes.
All right. Any complaints whatsoever?
None.
And Mr. Baldwin, I'll ask you the same question. Are you fully and completely satisfied with the service, advice, counsel of your representatives, attorney representatives in this case that have handled these post-conviction proceedings on your behalf? Any complaints whatsoever? And Mr. Miss Kelly, I'll ask you the same question. Are you fully and completely satisfied with the service of your attorney in handling these post-conviction proceedings and advising you and getting us to this point?
Yes, sir, I am.
Have any complaints whatsoever
Sir,
towards
I
your
have not.
counsel?
No, sir.
The court finds that this is a complying plea within, that's a basis pursuant to North Carolina versus Alford, that there is a factual basis for the plea, and that the pleas are voluntary and will be accepted and received by the court. Having said that, the plea agreement in this case indicates that as relates to you, Mr. Eccles, the proposed plea and sentence recommendation would be that as to one count of first-degree murder, you would be, as to 3 counts of first-degree murder, you would be sentenced to concurrent sentences of 216 months and 78 days, 18 years and 78 days in the Department of Correction, with credit for that full sentence, 216 months and 78 days jail time, followed on one count only by a 120-month period of suspended imposition of sentence, subject to your compliance with certain terms and conditions, all of which are set forth on paperwork that you've been over with your counsel and signed off on. Is that correct?
That's correct, sir.
And is that a correct statement of the proposal in your particular case?
Yes, sir.
And Mr. Baldwin, as relates to the proposed plea and sentence recommendation in your case, the same recommendation would be made as relates to Mr. Eccles. You understand that?
I do not.
And you understand that it would be time served, and on one count it would be subject to a 120-month period of suspended imposition of sentence. Mr. Miss Kelly, you understand in your case that there'd be one count of murder in the first degree with the same basic sentence that's recommended as Mr. Eccles, Mr. Baldwin, and a 120-month period of suspended imposition on that single count,
Yes, Your Honor.
with two counts of second degree, as was the result of your first trial.
Yes, Your Honor.
Okay. And is that the correct plea and sentence recommendation in your case?
Yes, sir.
Okay. And in your case, Mr. Miss Kelly, you understand that if you should, during the course of the 120-month period of suspended imposition of sentence, fail to comply in any way with those terms and conditions, draw another charge, or otherwise violate the law or the conditions of your suspended imposition, you could be, that suspended sentence could be revoked, and you'd be required to serve an additional 252 months and 287 days, 21 years and 287 days in the Arkansas Department of Corrections. You understand that?
Yes, sir, I understand.
And that has been fully explained to you by counsel, and you've signed off on documentation to that effect.
Yes, sir, I have.
And Mr. Eccles, by the same token, a violation or failure to comply with terms and conditions of your suspended imposition of sentence during that time frame result in your being liable for up to 252 months and 287 days, 21 years and 287 days additional in the Arkansas Department of Corrections.
Yes, Your Honor.
You've each been over, and Mr. Baldwin, the same for you. Is that correct?
Yes, sir.
You've each been over your conditions of suspended imposition, which are not necessarily the same for each of you. There are differences but you've been over them item by item with your counsel and signed off on them in agreement of those. Is that correct, Mr. Eccles?
Yes, sir, I have.
And Mr. Baldwin and Mr. Miskelly?
All right, if you go through this, you're going to hand over the Bible. You're going to give the key to everybody.
Sir,
Death row.
sir, would you have a seat, please?
They'll go. That's what you're going to do.
Have a seat, please.
That's what this president's going to do.
Just,
Wrong, John. You can stop it right now.
all right. Does anyone have anything for the state to be said before sentence is pronounced in this case?
That's right.
Any defense counsel wish to make any additional statement before sentence is pronounced?
Just briefly, Your Honor, I would like to say that Mr. Eccles has had ample opportunity to discuss the arrangements, the plea proposal, the sentencing recommendation. Mr. Benka and I, he's gotten input from Mr. Reardon and Mr. Morgan and Ms. Nyrider through me. He's a bright, intelligent young man. He's making a voluntary decision.
Okay. All right. The court finds each of the defendants guilty of first-degree murder and the modified charges pursuant to the Alford case, even though they profess their innocence in connection with the matter. That's what this sort of plea is calculated to do, and to give folks a reason or way to end a matter of this nature in the best interest of everybody concerned. Having done that, the court will now pronounce sentence in this case. Mr. Eccles, each of you will be, Mr. Eccles, Mr. Baldwin, Mr. Miskelly, you'll be each sentenced to serve 216 months and 78 days, 18 years and 78 days in the Department of Correction on a charge of first-degree murder with full credit for that time already served, 216 months and 78 days, followed on one count of first-degree murder in each of these cases, Mr. Eccles, Mr. Baldwin, Mr. Miskelly, of a 120-month period of suspended imposition of sentence, subject to designated terms and conditions, which gives rise to additional liability if you fail to comply with any of the terms of the conditions. As the court indicated to you earlier on, this, even though it's a guilty plea with a profession of innocence, it's a guilty plea under the law, and it will go down for future reference as such. And in the event either of you should commit another offense of any sort, it could be used as a means of enhancing a sentence in that particular case, just as if you had gone to trial, been convicted and sentenced. Anything further to be offered by the state?
Have they acknowledged that they've read the rules of suspended sentence?
They've each, I've had them each acknowledge as we went along that they've been over the terms and conditions of their suspended imposition and signed off on them. That is correct, Mr. Eccles, Mr. Baldwin, and Mr. Miskelly. All right. The court having sentenced pursuant to the plea agreement, I'm advised that the Department of Corrections people are here to put in place the processing paperwork so it will not be necessary for either of the defendants to be taken back to the Department of Corrections and can be processed out here. There's going to be additional opportunities for some media contact with people, but not right now. We have some processing and things of that nature to do. I want everyone to remain in the courtroom at this point in time. I'm going to allow the defendants and counsel to take their leave from the courtroom, both for the state and the defense. I want everyone to remain in the courtroom except counsel and the parties that are subject to post-proceeding interviews. State counsel may leave as well, and as far as the plea agreement, the hearing is concluded. But I'm going to take about 10 minutes of your time, folks that are here in the audience.
Thank you.
We're still in session. The court's still in session, and I don't want any outbursts. I commend you for being orderly to this point, and I want that to continue. The court's very much aware. The court's very much aware of the nature of this proceeding and the extreme emotions that are there on both sides of this particular matter. And the court takes no position as to what occurred when this tragedy occurred and these innocent lives were taken. That's not part of what I do in connection with this. But I am aware of the divergence of opinion about that. I'm aware of the controversy that's existed. I'm aware of the involvement of the people in this case. And I commend people in the case that have assisted the defense, that have assisted anyone in connection with this case towards the end of seeing that justice is served to the best that we can do. It has been helpful. Counsel in this case have operated pro bono, which means without pay. DNA sampling and expensive testing has been done by virtue of money raised by caring, supporting people in support of the defendants in the case, and I commend them for that. Sometimes outside help is in fact a big help in bringing in giving us something that we may not have ordinarily access to or resources to. So I appreciate that, and for those of you who have been a participant in that regard that are here, I commend you personally and publicly for having done that. It's hard to imagine a battle that has raged this long in a particular situation. And I realize that this result is confusing. It's in the time that I've been on the bench, better part of 14 years, I believe it's the first time we've ever used an Alford plea. But this was a proposal that came to me by agreement between counsel and not something that the court suggested. But the court does believe that in this particular case, as I've stated, that it is in the best interest of everyone at this particular point. I think I've pretty well set out exactly what the effect of this is. There's not a lot of case law about this throughout the nation, except the United States Supreme Court case. And in Arkansas, there's not really any precedent to amount to anything as to the exact nuts and bolts of implementation of the Alford plea, although it's pretty well understood that an Alford plea is an acceptable way of disposition in Arkansas. And we've had excellent working between counsel in this case. Quite frankly, I held the earlier non-public hearing in this case in order that this court could be absolutely certain that there were not any unanswered questions. There was no, it's one that ordinarily conferences like this occur when you have counsel come in for the state and for the defense, and they meet with the judge and then they come back out, and then things happen in public. I believe that in this particular case, because it's the right thing to do, that the defendant should be actively involved in the process. I wanted them to be actively involved in the process. I did not want to hear secondhand from anyone what was going on. I wanted to make sure they were doing what they wanted to do, and also to make sure that they had been absolutely informed as to all the ramifications of this, that the state and everyone knew full well what was going on. And once I satisfied myself of that, and that was another reason that I was probably more vague about the aspects of the hearing than ordinary, because I wanted to make sure that that understanding, that level of understanding and informed agreement had occurred before we finalized it. And I'm pleased that we've done that. So this won't answer all your questions. I don't expect it to. It will give rise to discussions for a long time to come. I don't think it'll make the pain go away to the victim families. I don't think it'll make the pain go away to the defendant families. I don't think it will take away a minute of the 18 years that these three young men served in the Arkansas Department of Corrections. What I've just described is tragedy on all sides. Ordinarily, I don't talk this much about a case, but since I've got a captive audience here, and I do believe that this is an unusual situation, it's an unusual disposition, and I wanted to make sure that we are as transparent as we can be in this process. Let's hold on just a minute. I'm not ready to release y'all quite yet. How long we been? About 10 minutes? Okay, I think we're free to recess, and I ask you to do it in an orderly fashion. Let's let the media proceed first. So, bailiffs, if you'll help me with this process, we'll let the media proceed first. Anyone connected with the victim's family? Victim's family. I will, just one thing at a time. And let's give them just 2 or 3 minutes, and then we'll.
Approach and say thank you for accommodating me.
Sure. I'm glad we can work it out, Dan. Take care. Okay. Laura, he's serious. Soren says that he thinks he can get Mom a short one-on-one with Johnny and Santa.
I'm going to go for that. It'll be a 2-on-1.
But where is Eccles? I'm one shy. Have I signed it though?
Yes, sir, you did.
I did? Okay.
Judge, he's...
Steve? Somebody try to call Lori or...
Yeah, well, that's not good.
Why don't we just begin? Yeah, I did.
You guys want to introduce yourselves?
My name is Damian Eccles. I'm 36 years old and released today from death row for a crime I did not commit over 18 years ago.
My name is Jesse McPhillips, 36 years old. I've been released from ADC, served 18 years for a crime I didn't commit.
You get more?
Yeah. Lori's on the phone. Lori just come down here right now. Everybody else? Everybody, come on down. Yeah, everybody. Yeah. Lonnie. Everybody. Well, all the folks that are Lori and the family and Eddie and Natalie and those.
Monty, do you want them to start answering questions?
No, I would just wait. I would wait. I just want Lori and, oh, sorry, but we're just waiting for the rest of the family.
All the way down to the basement.
Yeah.
Yeah. Yeah, and you'll
They'll just
find.
stand behind me.
Real bad notice.
I say we give these guys a round of applause while we're.
Thank you.
Someone should make a movie about it.
It's coming out in 3 weeks.
Jesse, what time is your clock?
Where are you now? Damien and everybody.
I don't know what time is it.
Come on. Whatever, any way you can get down, we'll make a way.
Yeah. Lonnie's in charge. No, I think that's right.
Right. They won't let, where are you?
They'll come in.
Just, they won't let you downstairs?
Well,
Okay, I'll come up. Somebody has to get Lori and, they're being held.
Want to introduce ourselves, Blake?
Steve?
Yeah. Let's get started? Okay. Yeah, go ahead, Blake. Go around the horn.
Blake Hendricks, lawyer from Little Rock, represent Jason Baldwin. Obviously, my client, Jason. Erin Casanelli, who is, she and I worked together in Little Rock and is now part of the team.
Jeff Rosenzweig, and I represent Jesse Miskelly. Jesse's other lawyers, Michael Burt and Nancy Pemberton from California, could not be here today.
Steve Braga from Washington, D.C., represent Damien.
Donald Horgan from San Francisco, also represent Damien.
And Dennis Reardon from San Francisco as well, and I represent Damien.
Patrick Banka from Little Rock, and I represent Damien.
Laura Nyrider from the Center on Wrongful Convictions of Youth in Chicago, representing Damien.
And I'm Rachel Geiser. I'm the private investigator that helped work on Damien's case.
Good job.
Thank you. Christina Guybe, Center on Wrongful Convictions of Youth.
Cheryl Herman. I am a legal assistant with Patrick Benka.
Carol Benka. I'm Patrick Benka's wife and law partner.
Where do we begin?
Damien, six years ago I sat with you on death row, and we talked about when this day would happen, and here it is. Can you describe what you are feeling in this moment?
Still very much in shock, still overwhelmed. You know, you kind of have to take into consideration that I've spent almost the past decade in absolute solitary confinement, so I'm not used to being around anyone, much less this many people. It's kind of overwhelming.
Damien, was the Alford Plea, the judge said it was a plea he's not dealt with on his time on the bench.
Right.
You have to say, for the court's purpose, that you're guilty of a crime that you profess to the judge you did not commit.
Right.
Is this justice? Is this what you've been looking for? Is it bittersweet?
It's not perfect. It's not perfect by any means, but at least it brings closure to some areas and some aspects. You know, we can still bring up new evidence. We can still continue the investigations we've been doing. We can still try to clear our names. The only difference is now we can do it from the outside instead of having to sit in prison and do it.
Damien, Jesse, Jason, are any of you concerned about when you go out? There are some people who are still angry about this. Do you have concerns about that?
very much, yeah.
Why not? Why do you think?
I mean, I'm concerned because even when you're in prison, it goes on every day. You have to worry about your own safety. It don't matter what the crime it is. You still got to worry about your safety regardless.
Jason, how about you?
Can't worry about what someone else may do. I just have to, stay around the people I love and who love me and care about me and, just trust. Can't live our lives in fear. And as far as your question earlier, Damien, this was not justice, In the beginning, we told them nothing but the truth, that we were innocent, and they sent us to prison for the rest of our lives for it. And then we had to come here, and the only thing that the state would do for us was to say, hey, we'll let you go, only if you admit guilt. And that's not justice, no matter how you look at it. They're not out there trying to find who really murdered those boys. And I did not want to take the deal from the get-go. However, they're trying to kill Damien, and sometimes you just got to fight the gun to save somebody.
Jason and I have talked about this, and I think it's important to say. Jason was initially resistant to this proposal because it was against the principles and the things that we've been working for in this case. We achieved one of two goals today, and that was securing these young men's freedom. It didn't secure or get the ultimate goal, which is a finding that these young men are actually innocent beyond all doubt of the crimes for which they were convicted. Jason was initially reticent to this proposal as a matter of principle. I can only imagine the Sophie's choice that he faced in agonizing over this decision. There are many reasons that Jason, I know, made this decision. And one of them was that it took another man off death row. Jason literally saved a human being's life today. That's an honorable position. That has integrity. I can tell you that I have been so proud to represent Jason. I am prouder to be his friend because of the nobility and the honor of what he did here today.
He's a hero.
What's your name again, sir?
Blake Hendricks, H-E-N-D-R-I-X.
What about you, Damien? How difficult was this for you?
How
difficult was it for you to make this decision?
To be honest, it wasn't that difficult. I'm just tired. This has been going on for over 18 years, and it's been an absolute living hell.
Yeah, let me just add a little bit onto that, because these decisions are client decisions. The decision Jason made, unbelievable, heroic. Damien's decision, different places. You can't judge, second-guess these decisions unless you've been in their shoes. Spend 17 years on Varna, most of the time in solitary. You could ask, did you really do the right thing? He's the only one who's been there. He made the right decision.
Him every day in there.
Absolutely.
And what do you do now that, Jason, in your mind, justice hasn't been served, but yet you're free? What will you do
I'm
now?
going to live my life the best I can and enjoy every moment of it.
What's the first thing you want to do?
I don't know. I'm just kind of, going with the flow right now.
Now that you've been adjudicated,
My family and friends are, helping me and taking care of me.
is there anything that any of y'all, or through your attorneys or yourself, could tell the investigators that might point them in a different direction or toward different suspects? Is there anything now that you've been adjudicated and you can't be held guilty for or found guilty for or charged with it that you can tell?
I know I can speak for everybody and say no. These kids are absolutely innocent of the crimes for which they are convicted. Therefore, they have no leads to even suggest. Completely innocent and unaware of what happened out there at 10 Mile Bayou.
Jesse,
Dennis, you want to add into that?
Yeah, let me just point out one aspect of what happened today. These men not only walked out, they created today, by this plea, to me, proof positive of their innocence and the state's recognition of it. Because does anyone believe that if the state had even the slightest continuing conviction that they were guilty, that they would let these men free today? It would have never happened if the state hadn't come to the conclusion that the plea is entered today or their convictions are overturned in December and they walk free then. What it would mean is continued confinement. But to me, the state's acceptance of an Alford plea, in which they maintain their innocence, and releasing them is evidence of the state's recognition of their innocence.
How much of an
influence did
what do you think were the factors? What do you think were the factors that the state was most afraid of this upcoming evidentiary hearing? Alleged juror misconduct, the fiber evidence? I mean, what do you think they were most afraid of revealing?
Well, look at the court documents, because what the state agreed to today was a finding by the court in granting the new trial that there was such compelling new evidence of DNA along with all of the evidence that no reasonable jury would convict these defendants at a new trial. That finding had to be made before the plea could be entered. And I think that it's an implicit recognition by the state that is the finding that would have been made at the hearing in December.
How much of an influence did the national publicity have on this?
Let this guy go.
And the support from the celebrities, the national publicity, the fact that perhaps the state didn't want to go through a highly publicized trial again. How much did that impact what happened today, the resolution? Sorry, Damien, anyone?
I think it had a pretty big impact just because they knew they wouldn't be able to get away with a lot of stuff that they got away with the first time. They knew there would be more people watching this, more attention on this case, so they wouldn't be able to pull the same tricks. Basically when we went to trial the first time, they came in with ghost stories, rumors, innuendo, things that really had nothing to do with the case whatsoever. And they knew now the whole world was watching them. They wouldn't be able to do the same thing. They would have to come with some sort of concrete physical evidence, and they didn't have any, and they knew that.
What have you guys talked about now that you've been back together?
We haven't really had much time to talk about anything because we've been in separate places at the jail and, just the few minutes that we've been together before the hearing and now, so we haven't had a great deal of time to talk about.
Is there anything you can say about Jesse?
Lori's with you now.
Yes.
Talk about what her role in all of this has meant for you and the case as a whole.
Lori is the thing that's kept me strong and sane, that's allowed me to survive over the past 18 and a half years. If it wasn't for her, we wouldn't be sitting here right now. She's probably done more work on this case than anyone else who's been involved with it from the very beginning. She spends pretty much her every waking moment of every day working on this case.
Mr. Baldwin, can you talk a little bit about coming to the decision that this is something you need to do for initially?
Excuse me, sir? I'm sorry.
About coming to the decision that this is something you did not want to do, but you decided you had to do.
I was willing to, if it was just me, as much as I'd hate just be in that place, I'm obviously ready to get out of prison. I want to be out, deserve to be out. But I was ready to fight it for trial and court as much as possible. But he had it so much worse than I had it, on death row, and it's just insufferable to put a person through that and for any more minutes. And I don't even know why I didn't even think too much about that at first, when the plea came to me. But I'm just glad that he's out now and he's going to be with his wife and, surrounded by people who love him and care for him, and it's not just intent on hurting him.
I want to publicly thank Jason, too, just to let him know that I do acknowledge what he did, that he did want to keep fighting. He didn't want to take this deal in the beginning. And I recognize and acknowledge that he did do it almost entirely for me. Thank you.
Mr. Braga? A few minutes ago, the state stood up and demanded that these guys they believed that they were the guys who did it. How do you guys feel, having worked on this case, having reached this resolution, knowing that the state is still asserting the guilt of these guys?
Well, as Dennis explained a minute ago, when you look at the case, the way it's resolved, you just don't see that. The Alford plea is a very unusual plea. In doing 30 years of criminal defense practice, I've only seen it once or twice before. Prosecutors usually say when you put that on the table, no, there's no way you could plead guilty and maintain your innocence. Either you say you didn't or you take the regular plea. But this deal they took, and they took it because they wanted finality. I think they wanted it as much as we wanted Damien off death row. There is no doubt on this side of the courtroom that these guys are innocent. None whatsoever. And as strongly as they may think their convictions are valid, we think they're invalid. And history will judge that, and you made some of that history, Joe, so thank you.
Do all of you have to stay in Arkansas?
No travel restrictions.
Damien, what's the first thing that you're going to do now that you're free after 18 years?
Rest. You know, ever since we found out about this, I haven't slept. I haven't slept for about 4 days now, and I'm just completely and absolutely exhausted.
And Lori, you've been fighting. I mean, you single-handedly helped get most of this accomplished. Tell me your reaction today. How do you feel?
Well, I wouldn't say single-handedly. But, well, I'm just thrilled with, with the results. We have these 3 men out, and I have this man that I love very much with me, so I'm thrilled.
Ladies and gentlemen, Jason's not used to this. He's ready to go, so Jason and I are going to excuse ourselves. Thank you all very much. Jason wants to send his greatest regards to my co-counsel, John Phillipsborn of San Francisco. Of all of the lawyers here, the one lawyer that's been on this case the longest, and to me, the architect that built a case of innocence for all 3 of these men. And Jason and I want to say thank you, John. Hope you're watching.
Jesse is leaving too.
Jesse, what's the first thing?
He's going to go see his father.
We will talk to you all again. This is just for now. We got to get out of here.
Yeah.